Tom Manzo, and I'm president of the California Business and Industrial Alliance. We're a trade association dedicated to bringing awareness to a crisis that affects every employer and freelancer in California. It's a crisis we call PAGA. So just real briefly, if anybody's not familiar with our trade organization, CABIA was formed in late 2017. And actually, Rich and Rob have been part of the founding of the organization and have been with us the whole time. We have more than 150 members, and we have our board is made up of business owners and some who have been affected by PAGA. We also work with a lot of other trade associations, probably more than a dozen right now, where we're doing things. We're trying to work with legislation, building coalitions, attempting to get the word out and let people know what the problems are with some of the labor laws, especially PAGA. And, you know, we feel that we fight on behalf of all California employers, regardless of size. So our trade association is a little bit unique. We don't just focus on one group of employers. We focus on anybody that has an employee. It can be a nonprofit, it can be a religious institution, it can be a restaurant, it can be a manufacturing company. Any type of company out there we can handle. So really quickly, Rich Fry, he's a partner at Nixon Peabody's, their labor and employment group. Rich is seasoned litigator, he's a trial lawyer, he's got a long track record of high profile victories, trade secret, employment, mobility, complex business litigation, wage and hour class action disputes. Rob now, he is a partner at Nixon Peabody Labor Employment Group, specializes in wage and hour litigation. And I've dealt with Rob on many cases with some of our members and some of our clients. And he does a lot of analytical and compliance tools that help defend class action and PAGA lawsuits. And he's done a great job with anybody that he's worked with. So, Rich, go ahead. You want to take it from here? Go ahead.
Sure. And Rob, feel free to interject when you want. Nice to see everybody. I think I've met most, if not all of you. I thought we were going to do this on the Roe v. Wade decision that apparently we learned about last night, but I guess we're going to stick to arbitration for now. And Jane has already showed everybody what to do. If you have a question, just use the chat feature and we might be able to address it right there. I want this to be an interactive discussion, not just a preaching event. I'm going to give you a little background. These slides, I think Tom can make them available to anybody after the presentation. So I'm not just going to read the slides to you, but they serve as something for you to look at and read while we're discussing the general topic of arbitration. There are two main decisions that the court. Hold on, Nagar answer yes. It's being recorded. There you go. We have our CABIA case against the state of California, which is to basically challenge the constitutionality of PAGA based on the separation of powers theory. That's not the focus of this discussion, but the decision that we're challenging effectively is the Iskanian decision, which was decided by the California Supreme Court. And in that decision, Iskanian, while finding the separation of powers doctrine to not be violated at the end of their decision, the main part of the decision basically said that PAGA cases, because they're being brought on behalf of the state, cannot be arbitrated. They cannot be subjected to an individual's arbitration agreement. Flash forward, we have the Viking River Cruises case, which recently cert was granted by the United States Supreme Court. So the US Supreme Court is going to rule on the Federal Arbitration Act and whether or not the federal law, the federal law governing arbitration, preempts California's decision that PAGA can't be arbitrated. And that's why Iskanian is a part of this discussion and is definitely what's being considered in the Viking River Cruises appeal. CABIA, I think we can go to the next slide. CABIA filed an amicus brief in connection with that decision, and which is I think a huge step in this young organization's growth. We engaged counsel in Washington, D.C. They filed a brief that focused on the issues that are important to us, and we got rave reviews on the brief and a lot of publicity in connection with that. A quick update from our current lawsuit against the state. In about 2 weeks, I will be arguing in front of the California Appellate Court about the separation of powers. And if we are successful, we will end up going back to the trial court with an opportunity to prove that the separation of powers doctrine is violated by the delegation.
Hi, Jules, what's up?
Hello, is there a question? Maybe not. So that's the basic update. It's already been fully briefed. We have our argument, as you can see on the bottom of this slide, May 17th at 1:30 in the afternoon. So now let's get to Viking River Cruises. The basic issue on whether or not a PAGA claim can be arbitrated is the question of whether the California state entity, the labor commissioner, the LWDA, the Labor Workforce Development Agency, or just California as a whole, the executive branch, is being represented in that PAGA case. And if they are, the argument is that an individual, a private individual's arbitration agreement with an employer can't be enforced, and therefore you go to court. For those of you who have had the good fortune to see what PAGA is and have it visited upon you, you know that the state of California is not involved at all. That's the reality. The state of California isn't listed as a plaintiff in the case. Just John Doe employee is the plaintiff. And what's sad about this is John Doe employee doesn't even show up at the mediation. It's John Doe employee's lawyer that is basically the party in interest, because he, and I can say he because there aren't too many she plaintiff's lawyers in this area, he is seeking his payment of his attorney's fees, which can be egregious if any of you have engaged in this area of law.
Rich, I can take this one. This is a unique distinction. Yeah, so there's a distinction between, I would call the wisdom, or at least the politics, of state and federal courts in California. And you do see that federal courts tend to be more logical. And so Tom highlighted this case for us. We briefed out for him a little bit, did a write-up not too long ago. So the federal courts don't buy the key time analogy. As Rich was saying, the reason why these cases, quote unquote, can't be arbitrated is because the state, who is not involved, didn't sign the arbitration agreement. And that goes back to an old Latin word called key tam, which is on behalf of the king. So the fiction is that PAGA actions are really brought on behalf of the state, even though the state has no involvement. But federal courts just don't buy it, at least in some contexts. This Magadia Walmart case, what happened is the defendant challenged, said, look, under federal law, and really under most constitutionals of all the states, you have to be injured in order to bring a lawsuit. It's called injury in fact, right? You need that as one of those check marks in order to sue. PAGA, among many other things, does not require injury, because the theory, again, is that the state can do kind of whatever it wants. The state doesn't have to be injured in order to regulate its jurisprudence and its laws on people. But the Ninth Circuit just did not buy it. Here, there was a pay stub, a technical pay stub violation, or alleged technical pay stub violation, and the plaintiff wanted to collect PAGA penalties on that basis. And the court said, no, in order to be accepted from the key tam, the classic key tam. Now, Rich does a lot of litigation in this space. It's called the False Claims Act. And Rich, can you kind of circle back on that when I'm done with the slide?
Sure.
And so a key tam, in order for the exception to apply, it actually has to operate like a key tam. And so here, the reason the Ninth Circuit gave, which are very reasonable, is that the outcomes of PAGA lawsuits impact more than just the state, namely the interests of the non-party employees that this person seeks to represent. And really importantly, and this is part of our lawsuit, or Tom's lawsuit against the state, is that PAGA represents a complete and irrevocable handoff of power to the state. They can't go back and get it. They can't intervene. Indeed, I mean, the only people that even look at this is the court when they stamp, when they swing the gavel and approve a settlement, and then that goes to the LWDA for approval, right? But very rarely does the LWDA step in. So, Richard, do you want to touch a little bit on False Claims Act and how it differs?
Sure. The False Claims Act is a traditional claim a lot of people, a lot of healthcare companies get hit with it because they do business with the state through Medicare. And what happens is somebody at the healthcare institution believes that there's fraud going on. Somebody's overbilling the state, and they go get counsel and they file what's called a qui-tam relator case, which is actually directly on behalf of the state, because it's the state of California or the federal government, the United States of America, whoever the state is, they're actually the ones being defrauded allegedly by the healthcare company. And so they bring it on behalf of the state. Either the local district attorney, the private, the public attorney general, or the U.S. attorney general, depending on who the party is, has extreme control over that case. They can take the case, they can dismiss it if they want, and at all times they are there to tell the court whether any settlement is in the interests of justice. None of those aspects exist in PAGA. And that's why we think there's a distinction, and we think the distinction has a meaning, and therefore it violates separation of powers.
So that's great, Rich. We're going to switch gears into what is arbitration, kind of do a quick overview of that. So essentially arbitration is out of court resolution of a problem, right? Essentially two parties agree via contract. It should be no different than any other contract. We'll get into some of the reasons why it's not, or why it's not treated that way a little bit later. But essentially just saying, look, we want an experienced neutral to decide this case instead of going to court. And historically it was cheaper, and there are lots of benefits to it. We'll get into some how that has changed, generally speaking, but that's the overview of arbitration. And we're going to talk about how you can enforce it. So the Federal Arbitration Act, which goes back to 1925, it basically says arbitration agreements between two private parties must be treated by courts as valid, irrevocable, and enforceable, except on the grounds that you could invalidate any other contract. Fraud, duress, unconscionability is a big one. Essentially, is a contract so vitally unfair that a court won't uphold it. And an FAA arbitrator's decision should bind the parties in almost all circumstances, unless it was coercion, there was evident corruption, the arbitrator just didn't do its job, or the arbitrator went beyond its his or her basically her mandate, basically exercise powers that were not given to them by the parties. And then Rich, if you want to do the back and forth on the benefits of the arbitration and talking about class waivers.
Yeah, and this is the real focus of this. So anybody that's fallen asleep now's the time to wake up. We're not talking about law anymore. Now we're talking about the reality of running your business and whether you want to mandate arbitration agreements with your employees. And I use the word mandate lightly because there's some bad law out there that's been created by California. Right now it's enjoined, so it's not being enforced right now. But these arbitration agreements should on their face appear voluntary, and we can help you roll out any kind of a voluntary arbitration program, and you'll get most, if not all, of the employees to sign, because they just tend to sign things when they're onboarded as an employee. So there are ways to get this, and this is a hot issue right now, because when wage and hour class actions were all the rage, there were some that theorized that a wage and hour class action waiver in the arbitration agreement would require that under the Federal Arbitration Act, that the class waiver be enforced, meaning that a individual plaintiff could not bring a class action. They would have to arbitrate an individual action. PAGA was the workaround for the plaintiff's bar. All of these wonderful plaintiffs lawyers that some of you guys have encountered, they figured that this PAGA case, which is effectively a class action because it is a large group of employees, it's a more limited action because they're only seeking civil penalties. But as we know, those penalties can stack and can turn into huge awards, especially attorney's fees. That was an exception to the enforcement of a class waiver. And that's what's being heard. And we should get a decision this June or July by the US Supreme Court, assuming that PAGA and class can both be waived under an arbitration agreement after we get after we get the Viking River Cruises decision. Anybody who isn't using arbitration should give strong consideration to implementing arbitration. Go back, right? Because I want to go through this list. I just want to highlight.
Now I have to go backwards, which I don't know how to do. Let me try to go this way. Nope. Okay. So let me go. Okay, I got it. There it is.
Okay, so I just wanted to set the tone for why I'm going to talk about the
Got it.
benefits and drawbacks of arbitration. If the number one concern of your business is a wage and hour class action or PAGA action, and there are several businesses that are members of CABIA's organization that are high, they're low wage and lots of employees. So manufacturing businesses, we have some service businesses where employees go out and they set up things. Those are high risk areas for wage and hour disputes. And if that is your number one concern, your best answer to that is an arbitration agreement that waives arbitration, that waives class action and PAGA. Even though right now that PAGA waiver isn't effective in the state of California, in just 2 months, it may become effective. And that will nullify. It is a silver bullet. There aren't many silver bullets that I will be able to give you. This is a silver bullet killing the class or representative action. So you have to give strong consideration to it. I'm going to go down the benefit side of arbitration. I've gone to the bottom two. Speed, a lot of people say arbitration is quicker. It's not true. Arbitration can take years because the plaintiff's bar tries to turn it into a civil litigation. They try to make it more expensive for the employer, because that's the number one reason that arbitration agreements aren't great for the employer is under California law, and this is one that's not being challenged, and frankly, I don't think ever will be challenged. Under California law and under, I think it's almost every other state in the union, if you enforce an arbitration agreement, the employer pays all of the costs of that arbitration over and above what would have to be paid had the employee gone to court. And let me repeat that. In California, to file a lawsuit, it costs maybe $500. In California, to hire an arbitrator, to arbitrate a case, that only takes a week, 5 days of arbitration, the cost could be $40,000, $50,000 in costs, in addition to paying your attorney. You don't have to pay the other side's attorney, but you do have to pay the arbitrator. And those costs have skyrocketed. So arbitrators are charging $5,000 to $10,000 a day. Some even charge more to hear these cases. And the plaintiff's bar knows it. And so they try to drive up the costs so that you ultimately have to settle. So that is the biggest reason to not implement an arbitration agreement. One of the things that, and then I'm going to go to the fourth one, mass filing retaliation. What has happened, and Uber experienced this, I think DoorDash might have experienced this. So other large putative, I say putative because Uber and DoorDash would say these aren't their employees, they're independent contractors. They enforced class waivers in connection with some wage and hour actions that were filed against them. And the court said, you're right, class waiver, they have individual claims. Well, the law firm that was bringing the claim on behalf of the putative class was a very sophisticated and organized law firm. A lot of California law firms, plaintiffs' lawyers, are not this sophisticated and organized. They went and got in one case, I think it was Uber, 80,000 individual arbitration claims. The AAA, I think it was in that case, issued a bill. My understanding might have been $10 million for the administrative startup of those claims. Uber, of course, objected. They said, no, we can't do that. They went back to court. The court laughed at them and said, you wanted me to enforce this agreement, I'm going to enforce it. So you have 80,000 individual claims. So that is a drawback that some people will point you to. Now let's get to reality. Because what a lot of lawyers out there do, and you'll see articles about why you shouldn't have arbitration agreements. That's not in the interest of the defense. My bar, the people that my peers don't have an interest financially in you protecting yourselves from wage and hour class actions and PAGA cases, because we're not needed anymore. I told you it's a silver bullet. And some of the worst defense lawyers can even employ this silver bullet. You don't need a sophisticated lawyer if you have the silver bullet. So you're going to read articles about how the costs can be exceedingly egregious. Well, if you ever want to talk, and if you're a member of CABIA, as you know, I take these calls. I don't charge anybody. If you want me to represent you in a case, we give you a discounted price, but I have no problem fielding calls from any of you. The reality is there are clauses that we've come up with that you can put in to allow you to consolidate cases if they go to arbitration. So there is an answer to the mass filing issue, but let's also be realistic. How many people who are on this call have 80,000 employees? How many have even 1,000 employees? It's, to me, it's a phantom issue to scare you into not having arbitration. And I don't support it. So I'm happy to talk to you. You are one of those employers that has 1,000, 5,000 employees and you're worried about it. There are ways that you can deal with it. I still think avoiding a class action and a PAGA action should be the number one issue, because if any of you have talked to me and you've heard me say, I don't think, I've been doing this for almost 25 years. It's unbelievable. The reality is you can't know all the labor laws. The book, as Tom will hold up, is like 3 inches thick. It might be 13,000 rules or something like that. You're violating one right now. There's no doubt. And the plaintiff's bar is looking for it. And these rules aren't just the laws in the labor code. They're also the wage orders that every now and then get adjusted by these ridiculous people that run those agencies. So you don't know what you're not doing right. And so while I'll help you with minimally complying with the laws that the plaintiff's bar is really focused on, you're always at risk in this area with a class action or a PAGA action. This is your silver bullet. So a lot of people will say, just do better with how you regulate your businesses. I'd love to hear some of your war stories who thought you were doing a great job and you still got sued. That's the problem. So please send questions. Please let's leave some time at the end. We can have an open dialogue. Focus on this list. Everybody take a look at it. Rob is going to move on, but this is an important slide here for whether to do this or not. And knowing full well that Viking River Cruises is likely going to go the employer's way, I think it weighs heavily in favor of having arbitration agreements.
Right. And the only thing I've added is that we're working on a case right now. We're rolling out arbitration agreements in a post-lawsuit context. And we've just completed a survey of all the stupid decisions the California Court of Appeal, excuses really, has come up with to invalidate agreements. Things from the text being too small, from it not being a separate agreement, from ticky-tacky little things. So if you guys have arbitration agreements, I would highly encourage you to have them reviewed by counsel, because courts are looking for reasons to invalidate them. I think I have 37 different bullet points on different cases where they went through and found some truly ticky-tacky reason not to enforce it. Another thing I'll add is, Tom has done a great job through a related entity called CABIA HR of helping with what we call optical compliance. So it is making sure your pay stubs don't have any obvious violations, making sure your meal period doesn't say something silly like the meal break should begin after the end of the 5th hour, which of course isn't right. And when Tom first started this organization, and Rich and I were showing up at these things, Rich called it low-hanging fruit. And I think, was it just minimal compliance, Rich? Is that what it was called?
Yes.
Minimally comply. And the idea is you just don't want to be the easy target, because as Rich alluded to, these counsel are not sophisticated folks. Indeed, one thing I will admit to is I'm actually close to the attorney who's actually bringing the Viking River Cruises case. Not a bad guy, actually, pretty reasonable. And he hates most of the guys in this field because, he actually brings real cases for real violations. And a lot of these people, they just have these crappy lawyers that barely finished law school. And PAGA is so easy and it is so employee friendly that any idiot can bring one of these claims. They're very difficult to defend. So just high level view, and Rich already touched on this. What happens if Viking River Cruises, comes out our way? Essentially, the Federal Arbitration Act, a federal law which supersedes state law, will allow us to enforce well-drafted arbitration agreements and basically get rid of PAGA actions. And part of that is that, so these represented PAGA actions, there is a question of whether or not the PAGA action would even exist. The district courts in the Ninth Circuit have said essentially that there is no such thing as individual PAGA action. By its nature, it's representative. So when we're talking about a silver bullet, it could truly be a silver bullet to these things, but you have to make sure your arbitration agreements are well drafted for specifically waiving representative actions, because PAGA, because the fiction again is that these are not class actions or representative actions. You have to make sure the proper kind of magic language is in there. And of course, if Viking River Cruiser does not come out our way, nothing really changes. We're in the same crappy position that we are right now. So
One second, Rob.
Yeah.
When you said the drive-by, did you focus on the pay stub? Did you say that?
Yes, pardon me, the pay stub.
Yeah, so that's what everybody should this isn't a how to avoid PAGA cases other than arbitration agreements seminar, but the reality is if you're leaving here with anything, it's whether you want an arbitration agreement or not. But number two is the core issue, which is make sure your pay stubs and everything that's reflected on them are clean, because that's the thing that the plaintiff's bar can get access to and what they base their lawsuit on. If that's clean, you're likely going to avoid the PAGA claim. They want to see it simply right there on the pay stub.
Got it. That's helpful. So we kind of covered this. So essentially, I went through all this to the last bullet, and because plaintiffs' lawyers are nothing if not creative, because this threatens their pocketbook. And Tom, maybe you can speak to this because you're the one with the ear on the ground in Sacramento. They're already looking at a workaround. They're looking to, because again, this is thick as thieves. The legislature and the plaintiffs' bar, if they're not strange bedfellows, they're just bedfellows. And so they're looking at another way to work around it. Some potential options would be to have the state directly engage them. One way or another, it'll make it harder for them to bring these cases, but I would be surprised if PAGA doesn't come back in some form or another, even after Viking River. But that doesn't mean we won't have a short reprieve from this craziness that's going on right now. And so with that, we're moving on to questions. I think we already have one. Okie dokie. This is Eric Estrada. Okay, so Eric Estrada has this very specific question. I'll address it separately. It's a very long contractual quote. Getting ready to roll out an arbitration agreement and class action waiver. Would this clause help us against PAGA? Waiver of representative actions if permitted by law. Employee and employer expressly intend and agree that the provisions of this paragraph 5 apply and preclude the bringing of any claim which the employee or employer purports to represent the interests of any other person in a representative action. So far, so good. Employee and employer expressly acknowledge and waive the right to bring any particular action in any arbitration, state or federal, except that if existing law at the time representative action is asserted as unenforceable, the employer's agreement with his employee to arbitrate waivers of a claim part of this Generals Act, such claim would be considered as covered. So yeah, it's good language.
Yes.
It's a bit heavy, but it's good language overall.
And put that in a voluntary agreement,
Mhm.
and it gets better. Make it clear that it's voluntary, and it gets a lot better.
And to Abdulia just asked, does the arbitration have to be in Spanish? That is one of those very, very common substantive unconscionability, procedural unconscionability points that courts make. If you have an ESL speaker, yes, you're going to want to present it in Spanish. Some things that we have people do is we draft an English arbitration agreement, have it translated by a certified translator, right? And then the agreement is presented to them in both English and Spanish. You have them sign both, and you keep the certification. Buy it. So, and you make sure you allow them to ask questions if they want an interpreter. Really, any procedure, and we can give you a lot of help on this. We've looked at a lot of situations. But yeah, any little ticky-tacky unfairness or procedural issue, they're going to latch onto. That's a good question, Abdulia. Yes.
And let me just plug CABIA HR right here. Tom has created a very interesting and useful system where you could roll out arbitration agreements via the web, via online. And you could have both the Spanish, English translation. You could probably have the certification about it being proper Spanish. And the person will sign it and it'll get saved right away into the personnel file that can be stored and easily accessed. Because you never know when you're going to need it. It could be 5-10 years from now that you need to find this arbitration agreement. And you don't know how many clients I've represented that don't have the arbitration agreement in the file. And sometimes I'll be 2 years into a case and the HR person sends me, oh, is this relevant? And it's an arbitration agreement.
Yep, too often.
So getting your files, your personnel files, and with the way technology is today, getting those files up and running and active and solid and safe, that is huge. You don't know if you're gonna have the same HR person every year in, year out. You never know when you're gonna move on from some HR person. Who knows whether that individual moves up in your, I'm not saying they're gonna get fired, but they could move up, and whoever they hire, you can lose track of what you have. So to me, using an electronic database to store core key employee information is huge. And it's something that we can help you with a declaration that this is an affidavit that you would file in court to authenticate the documents. So even if we're not your attorneys, 5 years from now, you get sued. Rich is no longer working. Rob, you can't find. Okay, you hire a lawyer. Here's a declaration, an affidavit that authenticates the document. It shows you the exact process by which we entered into the arbitration agreement. And you just print it out. Well, that's huge. And the cost savings because of technology is unbelievable. So that's what I would do if I were rolling it out. I would also get it stored electronically and have everything stored in the same place.
Well, yeah, that's, and Abdullah
The
had another
best time
question.
is at the beginning of employment. So Abdullah asked a follow-on question: when is the best time to present ARB to employees? In a perfect world, and Pedro will get to you, I see your hands up. In a perfect world, you would enter into the arbitration agreement after the dispute arises. But the problem is the employee then has a plaintiff's lawyer already on their side, and they'll never agree. So the best time to present it is at the beginning when they're signing everything that they're given. That's the best time. And as long as you paper correctly and it reads like a voluntary agreement, I believe it's going to be enforceable unless and until the US Congress creates an exception to arbitration. They'll have to create a law where they say the Federal Arbitration Act does not apply to employment contracts generally. And they do have the power to do that. And they've talked about it under Obama. That was supposed to be one of the things he was going to do, but he had Obamacare, and I think he lost all of his ability to do anything more than that. So they talk about it all the time. But right now, the only thing that they're targeting is carve-outs for sex harassment. And that's huge for us. Let them carve sex harassment out from arbitration, but everything else is in. That's a win for employers. Pedro, question, and I think you have to unmute him.
Yes, hi, good morning, guys. Thank you very much.
Sure.
I have a question about, I know more of an update on what to do with, obviously, we've had already employees for in our business. So with this we had an arbitration agreement in place, but then since the Supreme Court took this case on, we got it reworked by counsel, and then some people didn't want to sign. It's like, I don't want to sign this, blah, 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 even though they didn't know exactly what it was, but explain it. And, we had about 20% of our employees didn't sign it, or 15% or so. I know there was a lawsuit or something in the pipeline too, that was about, the voluntarily things about arbitration agreements. So since we're talking about arbitration agreements, can you provide an update on that, or kind of?
Sure. So that, I believe that's AB 51.
Yeah.
And it is on appeal in the Ninth Circuit. And right now, I think you're good. If you force an employee to sign, and I'm going to use the word force in this call, and I'm going to just say, don't repeat that I ever said that word. If you force them to sign, I believe under the way you read the current case, that as long as their signature appears on the page, it's preempted, and it's going to go to arbitration. The law would be preempted. But suffice it to say, whoever you're using, you got a great result, in my opinion. If you had an existing class action and or PAGA, and you went to the employee complement and only 20% didn't sign, that means you just knocked out 80% of the claim. That's the way you should view that. It's a huge success. To me, you take that and run, and you don't try to do anything to mess with the rest of the case at this point. That's how I would treat that scenario, and I'd be very happy.
And one thing I'll add to that,
Thank you.
there's some relatively recent authority out there talking about how if you have a substantial portion of the class that signed arbitration agreements, the way that works is you can't compel the case itself into arbitration, but no one who signed those arbitration agreements can participate in arbitration. So not only does that cut the class down from a numerosity perspective, it also makes the claim difficult to manage. And it also makes it not superior. There are several elements that go into a class action. So I'm sure your counsel is aware of this, but there's more than just one facet that when you get those arbitration agreements rolled out, it makes the case difficult to actually litigate as a class action. So not only do you cut down the liability, you may create a huge procedural obstacle for opposing counsel to actually certify the class, or in a PAGA case, make it manageable, which is basically the same thing.
And Pedro, I don't know who your company is and whether you're a member of CABIA, but if they are, as Tom knows, and as some of the other employers that are on this call know, I'm happy to talk to your counsel about strategies for how to use that. There's no hard feeling. I'm not here to try and take business or anything. I'm here to help. And most counsel have accepted that help and they understand. So I'm happy to join a call with your counsel if you want. But I think right now you've got a good situation.
Yeah, I did. Thankfully, I don't have a PAGA case going. It's just mainly just like obviously as a precautionary, kind of just HR procedure type of thing that we redid it and it made everyone sign it. So
80% voluntarily signed and a bunch and 20% opted out. Consider proposing it again. Consider doing a in-house kind of training about why arbitration is good, and then rolling it out again and see if you can get the other 20% or a fraction of them to sign.
Okay, thank you. Yeah, that's a good idea.
Hey, Rich, one point I wanted to make sure that we touched on is having the arbitration agreement could avoid kind of that drive-by. And if something became too complex, you could always not enforce the arbitration agreement. And I think that's probably important for everybody to understand. So maybe you could explain that a little bit better.
Sure, I'm going to explain that, and then I'm going to answer Natalie's question that just appeared in the chat. The reality is, so some people are afraid that if you have arbitration with everybody, that every claim that is ever filed will have to go to arbitration, and then you have that cost issue because the employer has to pay. The reality is, most times the plaintiff's lawyer, even if they know about the arbitration agreement, will file a state law complaint. They will file in court. And then it is your ability as the employer to pick and choose whether you enforce the arbitration agreement in that case. And we have advised employers often, if we believe that there are unique issues about that case that make it so that court isn't a bad place to be. Now remember, that means we're likely going to have a jury, and that's not a place that most employers want to be. But we believe we might be able to get summary judgment, or we believe the case is so good for us that it won't go wrong. We have advised the employer not to enforce the arbitration agreement, and you stay in court. So you can have your cake and eat it too. There's no doubt. So I wouldn't worry about that issue. On Natalie's question, Natalie, if you have the type of employees that you believe would sign, maybe yes. But I would not want people to opt out of the arbitration agreement by sending it to them again and not signing the next time. So my gut tells me don't do what you're proposing, which is to do it annually. You may present it annually to people who haven't signed it originally. I definitely don't, I wouldn't discourage that. But if you already have a signature, absent a change in the law, because what you're proposing would actually make it more voluntary, absent some change in the law, and we obviously monitor this day to day, I wouldn't engage in what you're proposing.
No, I want to thank everyone for your time. It's a very interesting and evolving legal landscape. Do reach out to Tom. He's made this his life's work. And through Tom, you get access to us. And we do this because we love it too. So it's always evolving, keep good counsel, keep an eye on these types of things. And even though this is a webinar about arbitration, that the optical minimal compliance, those pay stub reviews, of vital importance. I can't stress enough doing this day in and day out, how lazy these plaintiffs' counsel are. And if you don't give them an easy case, there's someone else that will. So in addition to keeping abreast of these issues and making sure you have good arbitration agreements, that should not be in lieu of, it should be in addition to doing your best to make sure that your threshold level stuff looks good from a California compliance perspective.
I have one thing, and I don't know if this can be an informal poll where people give us a thumbs up. and I'll answer Bruce's question afterwards. I've gotten a couple of emails from a new arbitration association over the last couple of weeks. I don't know if these are blasted to every labor and employment lawyer out there, or somehow they're targeting me because they know I've been speaking on this issue. But there's a chance that there's going to be a new association that's going to address some of the cost issues and maybe organize arbitration that may be more favorable to the way employers want it. Would people be interested in me pursuing whether or not this organization is a worthwhile candidate for this, if we could control costs through them, and then getting back to you guys through CABIA or some blast email from Tom? I'm just absent an absolute no, that's what I'm going to do. And hopefully, there you go, Victoria. We'll look into whether or not there's a program that maybe we can get CABIA to do and present, and we might even be able to get an additional discount because we're bringing 100 employers to the table. The risk, and this is what I'll look into, is that if you design an arbitration program that's too employer friendly, the California courts are going to say that that violates the law. We're not going to stack the arbitration panels with pro-employer arbitrators. First of all, there's only about 3 of them out there. So we're not going to stack them. But I would like to make it more usable by employers and more affordable. And I think this email I'm getting could be that. So I will do that. We have oral argument on May 17th. There's a good chance we would get a decision by the end of June, early July. If we're successful in bringing the case back to the Orange County courts, we'll get back on the docket probably before the end of the year. And the goal, depending on if we're going to win this, the goal would be to get right away to the court on the issue of whether Ascanian is a controlling, is somehow, if we can basically plead around or prove that the admission by the state executive branch that they're not reviewing any of the notices, the PAGA notices, is dispositive of the issue and violates separation of powers. That's the way that we would attempt to win the case right away. I believe the Viking River Cruises case, if it comes down in favor of employers, you're going to see a workaround from the California Senate and California government. I've already seen a quote that somebody said that they're prepared to respect the Supreme Court's decision. And what that means is they're prepared to draft a law that once again tries to get around the Supreme Court's decision. And we might have to file a new lawsuit because they may change PAGA in a way that tries to cure the separation of powers issue and put the labor commissioner or the labor workforce development agency as the plaintiff in the cases and hire out the plaintiff's bar to represent them, which presents a different separation of powers issue. So Bruce will be flexible, but I think we've gotten a lot of value out of our lawsuit. As you can see, our lawsuit, actually, the arguments in our lawsuit were used in the Viking River Cruises case. And I personally worked with the lawyer for Viking River Cruises on that appeal and with our lawyer who wrote our amicus brief. So this lawsuit that we filed in California has been tremendous for helping push the anti-PAGA movement. Victoria asks, when does PAGA go before the Supreme Court? It's already before it. It got argued. The Viking River Cruises case got argued late last month. I think, well, actually now it's not last month. It's the end of March it got argued. And we expect June, July for a decision.
June 30 is the end of the term.
And now it might get buried with this Roe v. Wade decision that was being discussed yesterday. But we expect this in early summer. And if it happens in a positive way, everybody should be ready. And I think you should already be implementing the PAGA waiver in your arbitration agreements in anticipation of a successful ruling.
Okay, well, I guess that's it, unless anybody else has any other questions or anything to ask. I appreciate everybody's time, and thanks, Rob and Rich, for taking the time to go through this with everyone. Really appreciate it.
Guys, one more thing I'm going to throw out there, and if I hear a couple of yeses, I have talked to Tom about whether it'd be helpful for the CABIA members to hear on other topics. Insurance would be one. Real estate. There are certain issues that in California confound small and large and small and medium-sized employers. And we have access to some pretty good brokers and insurance companies that actually, there are insurance companies that actually focus on private, non-public employers. One is called Hiscox, Hiscox. I believe they're out of Illinois. It's the one insurance company that I will tell you I liked working for because they did not try to control the defense. They were very respectful of the employer's wishes to litigate, and it wasn't all about the bottom line. So if you guys want to hear on topics like that, please let Tom know. We can do this once a month with Zoom. This is not that difficult. It's an easy way for us to get out there, answer your questions, and at the same time be useful. Because what I hate to do is to just blather on and on and on about something you don't care about.
Right.
I'd rather come up with stuff that can help you and that you care about. So if you have topics, if you have questions, you have Tom, you now saw our contact information, let us know.
And these are other legal topics, you know, anything that
Correct.
would regard legal when it comes to those kind of matters, just to be clear. So. Okay, everybody. Well, thanks again for your time. I appreciate it. Have a great rest of your day.
Thanks, guys.
Thanks, everyone.
Thank you.